Hey, what's up, everybody? My name is Sureshnie Ryder, and welcome to Study Sesh, a Boston broadcast production. We're so excited to help you unlock your knowledge. Today, we're discussing media law, and we're excited to have our lecturer, Cameroon Shan Makanaki, here with us. Cameroon, how are you doing?
I'm good. How are you?
I'm good, thank you. You're unpacking something that I studied many, many years ago, but has changed in this particular landscape in so many different ways. We're discussing intellectual property, media law, trademarks, and the laugh it off case. And immediately when I think about intellectual property or just understanding law, I always think of Taylor Swift. And I think about how she took back her power with understanding her actual law and what belonged to her and what didn't belong to her record company. But I wanted to unpack something about property and intellectual rights. Why is property and intellectual rights so important?
Well, Sush, it's very important to be aware of your intellectual property rights and that you have intellectual property rights in your particular country or jurisdiction in order to protect the creator of artistic, musical, and other works, patents, inventions, literary, whether it be musical, films, etc., to protect the creator from sharing the work with the world in exchange for protection. And obviously you as an individual or as a student or a person going into a work environment, if you want to create something that you want to be yours 100%, you need to be aware of the intellectual property rights. Because, Sush, what happens is, if you create something in the course of employment, you might be the author, but you're not the owner.
See, that's something we didn't know. I think a lot of musicians get this wrong. I know that Ed Sheeran has had so many musical cases against the Marvin Gaye family, for example. So you might create something, you might be the author, but you're not the owner. Now, that is something very interesting for
Well,
us.
in terms of a literary part, like for a book, for example, I see your context, you're mentioning music. Now, music is obviously governed in terms of other laws, copyright. The question in terms of music is who owns the beat? Who owns the lyrics? Where did they produce the song? Is there publisher rights? Is there a contract that they've signed? And in that contract, what percentage will the artist get in terms of royalties? Does the artist retain their intellectual property rights or not? And unfortunately, these musical contracts that you're referring to contextually, music, they're not very nice at all. I get a lot of students coming to me and they ask me for an opinion and I give them a legal interpretation of the contract. And I usually say to them, what is 10%? 10% of what? Because they are literally going to, if you got 100 Rand, for example, they're going to take 90% off that 100 Rand. And they're going to say, this is for promotion, this is for production, this is for publishing. And then you end up as an artist with practically nothing, which is why a lot of people are becoming independent. But on the other hand, if you know contract law and you've got a good presence on media, you might be able to negotiate your musical contract. Like, for example, Kanye West was very clever when he negotiated. And I'm sure Tyler, but I'm making a presumption, I'm sure Tyler was able to negotiate her contractual rights. If she wasn't, then she will do extremely well, and she's done South Africa proud. But I haven't seen her contract, and eventually, it's not nice to say, but in the music industry, you become a product. Yeah. So it's like the record company literally owns you, and any money they give you is an advance, and you've got to pay it back from actually generating revenue. Now, a lot of artists can generate a lot of revenue and pay it back, but some actually can't, and they end up with nothing. Just to respond to the musical context of copyright protection or musical works.
We're unlocking something that is so important, and I love this topic with Cameroon. We're discussing, obviously, media law, intellectual property law, trademarks, and the laugh it off case. Cameroon, let me ask you, where do we get our copyright and intellectual property rights from?
Right. So thank you, Sush, for the excellent question. It's always good to understand the origin of law. And I'm not going to give you a law lecture in terms of South African law, but the
Yeah.
origins stem from the Corpus Juris Civilis. And we go way back to Roman law, and then Roman Dutch, and then English law, common law, customary law, legislation, judicial precedent, presumptions, etc. But in terms of answering your question of copyright, initially, we have signed this thing called the Berne Convention. The Berne Convention is like an international treaty, which is like an international contract with countries that we have a link with. Because we signed the Berne Convention, we are a signatory. That has given us the right to intellectual property protection under copyright, and it has resulted in us creating our own Copyright Act, which is our domestic law and is pertinent to South Africans. And the same with trademark. We have our Trademarks Act, because you mentioned the Laugh It Off case, but that's more to do with trademark protection. But in terms of our copyright law, it comes from signing the Berne Convention. And we're not the only country that signed the Berne Convention. There are other international countries that have signed this. So now, in terms of being qualified for intellectual property protection, you've got to be a qualified person. You have to be a South African citizen or a person who is domiciled in South Africa, and that you intend South Africa to be your lex domicile, your country that you intend to be bound by. And if that is the case, and you have the right to be here, or you are a South African citizen, then you are covered by the protection on terms of copyright and the Berne Convention. And also, if you're a person of another country that signed the Berne Convention, you also qualify for copyright protection.
Cameroon, when we first started chatting, one of the first things you said, you need to understand the differences between being an author and being an owner. But what is the actual difference between author and owner?
So thanks for the question again, Sush. So in terms of owner, it means that you own, obviously, the intellectual property right, and the same with the author. But there is a difference now, because if you want to be an author and an owner, you create your work, maybe like an autobiography, and in terms of the contract that you enter into, and just for the listeners so that they know, a contract is an agreement between two or more parties where I have a consensus ad idem, my mind meets your mind, and there's an animus comprehendi, an intention to contract, so that there's a legally binding contract. Now, in terms of this contract, it is going to determine the rights of the individual who created the work, whether the person retains ownership, so that they own the right to do what they want with the intellectual property, and in terms of being an owner, but they also are the author, the creator of the work. And what's really interesting is a lot of people, they create work for companies, maybe even academic institutions. They create study guides, they write books and so forth, but they are obviously paid for that with a fee they negotiate. And when they do that, they sign a copyright agreement, which obviously gives the company ownership of the copyright. So that should illustrate who is the owner and who is the author. So if I write a book for Wits University, I might retain being the author, but I'm not the owner if Wits commissioned the construction of the book, unless I negotiate with them in the contract that I want to retain my intellectual property rights. Or if I don't sign the copyright agreement, ha ha ha.
Got it. Wow, I just feel like we're having so many aha moments where people go into contracts thinking, oh, I'm the author, this is going to be all about me, and then realizing at the end of the day, actually, it's not. I love that we're understanding this even better. Cameroon is unpacking media law for us, specifically with intellectual property rights, and we're learning about authors and owners. And one of the other buzzwords you would know is the word trademark. Cameroon, what is the definition of a trademark, and what are some of the characteristics that we look out for when we talk about a trademark?
So a trademark is very interesting. I always make a joke when I tell my students, it's a mark that we trade with. Ha ha ha. So what you should actually understand is maybe by example, the Nike symbol.
Yeah.
You know that little
The swish.
lightning
Yeah.
on the shoe?
Yeah.
Yeah. Or Adidas or KFC or McDonald's. Sorry for describing all the junk food that a lot of people eat. These are marks that people trade with. Now, from a business perspective, a lot of goodwill is built up on the trademark as well as the business. So it's very important for businesses to protect their business reputation and their trademark because it costs a lot of money and time to build up a respectable trademark. In terms of the definition, you might look at, and it might be a number combined with another symbol or a letter or a shape or a combination of a number, a shape, a letter, a shape, a number, all sorts of things together that when you look at that particular combination of pictures and so forth, you know, hey, this is Nike. Everybody knows. You see that? That is Nike. And that is a trademark. And we get protection under the Trademarks Act. And what's really interesting is there's a case called the Laugh It Off case. And it's very, very well known in South Africa. And it's quite interesting because it brings so many different elements of media law. Because in terms of the actual case, initially it was to do with the SAB, South African Breweries. And they say that Carling Black Label, America's Lusty Lively Beer. And then when it goes to the particular company that apparently violated the rights of the SAB and Carling Black Label, they actually said, if I'm not mistaken, white black labor guilt. Okay. And if you look into that, obviously you can infer whatever you want. And it even gave a year implying that the company is exploiting black people since this particular date by selling liquor, etc. Now, what you've got to remember is we've got freedom of expression and freedom of artistic creativity, according to section 16(1)(c). As I mentioned in the previous lecture, I spoke with someone else previously. So in terms of section 16(1)(c), artistic creativity, and we have the right to create something that is similar, but not the same. And what's really interesting is section 34, I think it's 1C of the Trademark Act. This is called the anti-dilution clause. And what occurs here is that Laugh It Off created a t-shirt where they put their little jokes about the Carling Black Label, and it looked similar, but not the same. Now, even though when they went to court, and there was a lot of different rulings in different courts, initially SAB won, but Laugh It Off got the last laugh, ha ha ha, because of freedom of expression. Yeah. And that similar was not the same. And also, what this case turned on was two things. One was dilution. Did the new logo or trademark dilute the brand? Meaning that would people actually stop buying Carling Black Label? Did they lose money based on this? No, they didn't. There was not substantial economic harm. In fact, there was hardly any because it was a joke on a t-shirt. Freedom of expression, the right to express, a society that is allowed to have humor. We have Trevor Noah. In fact, one of the judges was talking about humor being the cornerstone of South African society, and we encourage humor within our constitutional democracy. And the Laugh It Off, they definitely got the last laugh, and you can create these t-shirts and everything as long as you don't dilute the brand. And it's almost like Oros, you know, if you put too much water in Oros, you know, it tastes like water, it's no longer Oros. So at the end of the day, the brand wasn't diluted and economic harm was not suffered. So there was no particular trademark violation. Very nice case.
It's a cheers to Oros. Oh, wow. I love how you unpack that, Cameroon. I think that this is something that's so important for students to know if going forward as creators, where the blurred lines are and where you can get away with something and where you shouldn't. This is Boston Broadcast. This is hashtag Study Sesh, and we are in the middle of media law. I'm going to ask you, Cameroon, what are personality rights and the right to identity?
This is essentially important in South Africa because there are so many recent cases that I'm sure students are even aware of as we speak. And personality rights is the right to your personality and your identity. Now, Sush, if you don't mind, I'm going to make you an example.
Okay.
Okay. So, let's say, for example, Sush is a famous celebrity. Okay. And she walks into Checkers. Now, the lady in Checkers, let's say her name is Cameroona, okay? Cameroona comes up to Sush and says, Sush, I love what you do. You are so famous. You're an influencer. Can I please have a picture with you? And Sush, yeah, she models. She says, no problem, Cameroona, you can have a picture. Sush goes into Checkers. She takes the selfie and everything. And then Cameroona says, thank you so much. Can I please use this picture? And Sush says, no problem. So now, guess what? Sush goes home, she goes to sleep, she tells her kids at home, people are so nice in Checkers, you know, they literally follow me around and they really value what I'm doing and contributing to South Africa. She wakes up the next day, everything is fine. Goes to work, comes back, wakes up the next day. Then she finds out she's in the picture of Times magazine and she's actually having a picture holding, because when she took the picture, Cameroona asked her to hold some pasta. She's putting pasta above her head and saying that this takes her back to her Italian roots and that pasta is the best thing ever and you can only get it at ShopRite. Now, ever since then, ShopRite sales boom, revenue pours in. But guess what? Sush gave consent to this, but the problem is Sush had already signed contracts with other particular Italian companies for pasta, which is a violation of her contract. And on top of that, she was already considering and reconsidering, even though she couldn't because she signed a contract, because the way Checkers made her brand look. Now, when anybody looks at Sush, all they think about is ShopRite pasta. And she wanted to be associated with the best Italian pasta ever. Okay, so now her personality has actually taken a knock. An even worse example could be if Sush was holding baked beans and putting it on a big board when you are driving up to Sandton City and says, Sush, baked beans, endorsing them.
Yep.
So when anybody thinks about baked beans, that's all they think about when they see you. They think about nothing else. Your personality and your right to identity is destroyed. Because look, we do live in a society full of stereotypes, biases, and what's going around in society, what you're associated with, leaves a stigma in the media, which means you're going to either turn into a pastor yourself or baked beans. This is your right to not have your identity violated. Consent is important, and your right to image, because it is your particular image. And if people publish things without your permission and display you in a certain light, they are taking away, they are dishonestly depriving you of your right to identity with an intention to gain an economic advantage by enabling your personality to be endorsing their particular product.
Yeah, they basically leveraged your brand without your permission. And I think you might remember years ago, people didn't understand why Basetsane Khumalo was so upset when she visited a bicycle store in Northcliffe. And all she was doing is on a normal Sunday, trying out different bikes because she wants to get into a cycle race. And the owner took a picture, obviously, because this is a celebrity in his store, so excited. And Basetsane said, you're not allowed to do that. You know, she didn't sign an NDA. There wasn't some kind of talent form, release form that was signed from her behalf. And I think 10, 15 years ago, the law and the public did not understand. They just said, oh, that is very diva behavior. Meanwhile, she understood her brand. She understood the power and the leverage of her brand and her influence and people taking it away from her without understanding. And now that we have the reasons and the rights, it's so important before you take a picture in a store, and something for influencers to keep back of mind that this is what you're doing. You're giving people consent, and you say, hey, yeah, take my picture. And now look what happens. Media law there's so many components to it, and we're unpacking it today with hashtag Study Sesh and Boston Broadcast. Cameroon, let me ask you, what are the defenses to copyright violations or exemptions?
So there's a lot of exemptions, and I would argue to be defenses. Again, it depends on your construction and how you use the defenses. I always talk about rules of adjudum generis purposive construction, which is the contextual interpretation in terms of what exactly happened. But let's just answer the question in a simple manner. So first of all, if you actually have permission to use the work, then obviously you can use it. But you also need to acknowledge the author. So quotations is a defense. Just like we tell our students at Boston, you're usually going to lose 50% in second year and maybe 100% for plagiarism in third year if you don't have in-text referencing and a proper reference list. Now, it's the same in real life. If you don't put your acknowledgement in quotations, you are talking as if this is your work. And like when I talk, for example, I talk about a lot of different things that I've got information from books and I'm giving my interpretation. But if I'm going to talk about, for example, Kelson, when he invented the transcendental epistemological postulate, which means you've got to go beyond what you think you know to make clear what you assume. I'm going to say according to Kelson, and I'm going to acknowledge the author. That is a defense in terms of quotation. Another one is in terms of, this is not necessarily a straight defense, but in terms of exemption, how much of the copyright work have you used? So for example, earlier we talked a bit about music. Let's say you release a song on YouTube. Now all of a sudden, a person is giving criticism and review of that song. Firstly, was there permission to do that? We don't always need that because it's actually good for the artist to get exposure. But how much did you use of the song? Now, usually you can go through most of it, but let's say it's a movie. That's a better example. You can't criticize a whole movie without maybe the people who created the movie getting upset about it, especially if they didn't want to talk about that particular part yet. And then by analogy, we can then go on to reproduction of newspaper articles, which is another thing because we live in a society, democracy, freedom of expression. Now, if you're going to reproduce, that is exactly the same newspaper article. You can do it, but you have to do it if it's to do with politics, economy, and religion in terms of freedom of expression. Then you can reproduce it and you can discuss it because obviously it's pertinent to discussion. But if the author says, no, you cannot reproduce this article until I say so. I have reserved my rights and I am going to allow you to reproduce it or use it at a certain date. Then you're not allowed to because it's up to the author and the owner of the article. Okay, so be very careful with reproducing articles and so forth. Another defense is, let's say, for example, you are in town in Bree Street and you are filming, but in your background, you actually have graffiti or somebody's artwork, okay? Now, on the one hand, they're going to say, hey, that's my artwork, I'm going to sue you. But on the other hand, you can argue, no. The image was already in the public domain when it was being filmed. So it's already there. So it's a defense. Where you were filming, that is already there. Okay. And if that person hasn't protected their intellectual property rights, copyright on that particular image or picture, then it's in the public domain as well. Then hard luck for that person. So that's something to think about. If you create graffiti, you should protect your art. But then again, if you do that, did you do it legally or not? And you've got to think about that issue as well, which is also very, very funny and very, very interesting and makes intellectual property law a lot of fun to deal with. There's a few other defenses as well, like if you are giving information in the course of a lecture because you're a lecturer, okay, then to a certain extent, you're allowed to. Even under section 16 again, freedom of academic and scientific discovery. A lecturer is allowed to use this information for education purposes. So those are some of the defenses and exemptions. And in terms of the exemption, it's how much that you actually use when you refer to the particular person who's posted a movie or done a song or is talking about something. And then you look at permission and how much you're allowed to use.
Oh my word. I just imagine young creators right now on TikTok who are doing reviews, or people who are doing movie reviews or music reviews. This is going to be life changing for how they go forward. And also, this is so important for them to know where they stand and where the possibility is of them possibly being sued. Cameroon, I'd like to wrap up this session today because we've unpacked so many vital components of media law with regards to intellectual property, trademarks, etc. But I think what people are going to ask for them, for what's really important, is how does freedom of expression, which we all have rights to, affect intellectual property holders?
Now, Sush, this is a very interesting one, and we can sort of finish on this note because freedom of expression is an absolute right, except for there are exclusions under Section 16.2. Propaganda for war, hate based on race, gender, ethnicity, religion, and incitement of imminent harm. But there's also a limitation under Section 36 of our Constitution that if you apply it correctly, can actually limit any right within the Constitution, like privacy or the right to life. But in terms of intellectual property right and the argument versus freedom of expression, if we're looking at it academically, and it could enter into practice, definitely, but mainly from an intellectual perception or construction or conception, if we're looking at freedom of expression, now, if somebody creates something and they put it out there, me as a person who says, hey, I want to be free to use it, innovate it, manipulate it, use it, where's my freedom? Then we live in a society where freedom of expression is very important. But on the other hand, the person that has created the idea that is new, or if you register it, it will be deemed as new, even if somebody else thought about it, needs protection as well. So there's the debate between I will share this new idea or I will not. So if I'm going to share the idea and you are going to destroy it, put it out there in terms of public discourse, criticize it totally, violate my freedom of expression myself by actually now dishonestly appropriating the idea, claiming it's yours, etc., and then saying, hey, freedom of expression, I found this idea, or then claiming that I came up with this idea. Yeah. It's very important to protect the rights of the owner of something they create that they share with the entire world. There has been cases where, from a computer perspective, creating computer games, someone leaves it on their desk at work, the source code. They go back into their office, they find out that the programs are gone. Next thing you know, they've left that employment or they were fired for whatever reason. And then the same company, that it's not their ownership of that particular creation, it would just happen to be on the laptop or on the computer, takes the source code, releases the game, makes millions, and the person gets absolutely nothing. Okay, and there could also be the argument that even if it's your intellectual property, you didn't register it, so you don't have that copyright protection. But there's always an argument in South Africa about which right is, we got so many rights that we don't know what's right, or which right is bigger. And it's up to the court and the judges to either reason forwards or backwards and to decide which right is above the other. And usually they come up with the decision that no right is above each other, but each right has to be balanced and respectful of each idea. Mm-hmm. And that is a discussion that is going on. Freedom of expression versus intellectual property protection.
I think at some point you're going to have a lot of radio presenters at your door, Cameroon, because one of the arguments in my radio world with my former colleagues were they created a radio feature that became it was their talent, etc., but they used it on a public broadcaster's platform. They made it into a massive comedy show, and at the end of the day, it became commercial, and they were gaining money out of it. And the broadcaster said, well, hold on, you created this. It wasn't your idea. You didn't patent it. You didn't copyright it. So technically, you've basically taken our stuff and our work and you've put it out there. And I think that is such a fascinating way to understand that there is so much out there. Know your rights. And I think this is what you're saying. You should know your rights. Be completely complicit in knowing what you're doing. Know where you stand. If you're going to go into the checkers and someone takes your picture, make sure you either sign a release form, understand an NDA, do a talent. know, we talk about it now and you think it's silly, but at some point somebody doesn't realize the power of their brand. Next thing you know, they're Olympic superstars, but 2 weeks ago they were drinking an Energade, and people are going to think they've just endorsed that. So it's important to understand your rights. We have had the most incredible session with Cameroon Shan Makanaki, and I know that we're going to be back discussing more things to do with media law. But for now, we want to say thank you so much, Cameroon. Loved the session and I learned so much, and I hope we can also laugh it off, but at the same time be free to express ourselves.